I am happy to welcome you all here. Good morning to those who are in Moscow. Good afternoon to our esteemed speakers who are based in different jurisdictions in Singapore, Thailand, Philippines, Malaysia, who join us today. And just a small organizational issue, we are making a record of this webinar today, and we plan to publish it later with Russian subtitles so that more people from Russia and CIS countries will be able to watch our webinar further in internet. Today, our plan is to discuss arbitration in Asia, and we decided to organize this webinar because of publication of our joint book about arbitration in Asia. And first, this idea came to us with Tatiana Polevshikova, who is also with us today, and we decided that we see a lot of interest to arbitration in Asia, in Russia, in CIS countries, but there was almost nothing in Russian language about arbitration in Asia, so we decided that it's time to write something on the subject in Russian language so that people and in-house lawyers, first of all, of Russian and CIS companies will have some familiarity with the subject. So we're really grateful to our co-efforts from Thailand, Philippines, and from India, Singapore, who joined us today and who contributed to our book about arbitration in Asia. And we are really happy to have them here today. So our plan is to introduce shortly our book and to discuss importance of arbitration in Asia in general, and to discuss some cultural specifics of arbitration in Asia, because there are different jurisdictions, and of course arbitration is international, but there are also some interesting cultural specifics that we think will be of interest of our audience. We will start from our keynote speaker, and we are very grateful to Mr. Tan Sri Dato Cecil Abraham, who joined us today as our keynote speaker. We are really, really lucky to have him. He is a legend in this area. He is the senior partner at Cecil Abraham and Partners. He has a strong reputation for dealing with complex disputes as counsel and arbitrator. He has in excess of 300 reported decisions, and his practice covers a wide breadth of areas that includes corporate and commercial, environmental, banking and securities, insurance, maritime and competition law. Tan Sri holds the distinction of having acted for the former Prime Minister of Singapore, the late Mr. Lee Kuan Yew, and several Prime Ministers of Malaysia. Being regularly appointed as an arbitrator in domestic and international commercial arbitration, he is impaneled by the HKIC, SIAC, Asian International Arbitration Center, BANI, and multiple other institutions. Tan Sri is the only Malaysian to be regularly appointed as an arbitrator in investment treaty disputes. He has been regularly recognized as a leading individual by Legal 500 Asia Pacific Asia Law Profiles, and is ranked in Tier 1 by Chambers and Partners Asia Pacific, as well as Who is Who Legal in the area of dispute resolution for both litigation and arbitration. In 2016, he was named by Asian Legal Business as Dispute Resolution Practitioner of the Year. In 2019, he was named by Benchmark Litigation as Dispute Resolution Practitioner of the Year. And it's really an honor for us to have Tan Sri Dato Cecil Abraham now with us. So the floor is yours. Thank you. Thank you a lot.
Ladies and gentlemen, firstly, thank you very much, Anna, for those very kind words about me. It's a pleasure to deliver this opening address at this webinar today. I'm delighted to take part in the event, which aims to increase awareness about arbitration in Asia among the Russian-speaking legal practitioners and in-house counsel who are interested in this part of the world. The organizers of this webinar, together with representatives of the arbitral institutions and legal practitioners with diverse experience and knowledge of jurisdictional and regional specificities in the resolution of domestic and cross-border disputes. In particular, our speakers today will share very valuable insights on arbitration in Malaysia, Singapore, Thailand, and India. What makes arbitration an attractive dispute resolution method? It is a time and cost efficiency. However, it is not always possible to address procedural and cultural nuances efficiently. And it is quite often the case when it comes to resolution of disputes in emerging jurisdictions in Asia. Many of the Asian jurisdictions started developing their arbitration and ADR framework later than those jurisdictions which have been acknowledged as arbitration-friendly jurisdictions for years. However, it is impossible to deny the fact that Asia is blossoming in terms of its development and innovative resolutions in arbitration and other forms of ADR. Furthermore, if we look at the investment flows, as we will immediately notice the increase of partnerships and connections between China and the 15 capitals of the former USSR republics, as well as between Russia and ASEAN. What is the possible impact of the Russian-speaking lawyers involved in the Belt and Road projects for those who will work with ASEAN more closely in the light of encouraged cross-border trade? It is very likely that contractual disputes between such counterparts will arise, and if so, such a situation will require legal practitioners to represent their clients in a wide variety of disputes involving Asian and Asia-based companies or even states. In the light of international nature of such disputes, it is also reasonable to expect that disputing parties will be referring these disputes to arbitration or mediation or conciliation. Therefore, the initiative to publish a book on arbitration in the Asian jurisdiction is very timely. Although arbitration is a good example of how common law and civil law lawyers find commonalities for the mutual benefit of parties they represent, but it takes time and effort to absorb these cultural differences and to explain them to your clients and to come up with workable solutions. The authors of this publication have already summarized the most important information and shared examples from practice. The book contains an overview of domestic arbitration laws. It discusses arbitral institutions, their practices, recent cases, and procedural nuances, such as the admissibility and assessment of evidence, witness examination, and enforcement of arbitral awards. Furthermore, it is quite remarkable that all the chapters have been translated into the Russian language to make it understandingly easier for those who may have a language barrier or simply prefer to read it in Russian. Thus, this publication is aimed to help those practitioners who search for general information as well as some practical tips on alternative dispute resolution in Asia. Our audience today has a great opportunity to establish connections with those who have contributed to the book, exchange their thoughts and concerns, and contribute their comments and hopefully share their ideas and feedback for the benefit of all. I would like to encourage everyone to take a proactive approach. Awareness of procedural, cultural, and even language differences may significantly help the parties, their counsel, arbitrators, and arbitral institutions to understand each other and therefore to address the intricacies in a timely and satisfactory manner. I hope that you will not only enjoy a fruitful virtual session and learn more about the importance of arbitration in Asia, but also develop the newly established connections and share your invaluable feedback. The beauty of arbitration is in its diversity. And I believe that the launch of the book and our discussions today is a great step to promote understanding of arbitration in Asia among the Russian-speaking legal practitioners and in-house counsel. I thank you and congratulations to the authors and editors of the book. Thank you very much, Anna, and all of you.
Thank you a lot for your warm words. Thank you, really appreciate it. Let me introduce other speakers of our panel, because I'm really happy that we have such a distinguished panel today. I don't think that we have something like this in Russia or in CIS countries before, so this is a unique opportunity. So we have, I will introduce everyone and then we will have a panel discussion. So we will have today Abhinav Bhushan, who is Director of ICC Arbitration and ADR International Court of Arbitration Asia, in Asia. And he also, before joining ICC, practiced in India. So Abhinav contributed to chapter on India, arbitration in India. And today Abhinav will share some thoughts on arbitration in India and in Singapore, where he is currently based. We have Mr. J. Patrick Santiago, who is Senior Associate at Manila offices of Baker McKenzie, and who practices in Philippines and contributed to chapter on arbitration in Philippines. And first I met Jay in HKIC, where he practiced many years and worked many years. So it was probably 5 years ago, and I'm really happy to be in touch. We also have Mr. Suparyok Sakurgyon, who is a counsel in the Arbitration and Mediation Department of Thailand Arbitration Center Registrar. We really thanks Suparyok for joining us today for such short notice. His former colleague Litsan Chong contributed to a chapter on arbitration in Thailand, but she was not able to join. And Suparyok, thanks to him, joined us in a very short notice, and we're really happy to have him here. We also have Yana Vaivods, who is General Counsel in Spark Construction LLC Skolkovo, and she contributed to a chapter on China, arbitration in China, and she previously worked with a Russian law firm and had an internship in CETAC Hong Kong office, so she knows some specifics from inside. And we also asked to join us Alexander Molotnikov, because it's not impossible. It's impossible to imagine a webinar on Asia in Russia without Alexander, who is a very well-known expert in this field, and he is a chairman. Actually, he has many roles, but also he is a chairman of Russian-China Law Society, and he is author of many books on the topic, including books on Asia. And he is also professor, is one of the leading Russian universities, and many more. So thanks a lot for. Important person, my co-editor of the book, Tatiana Polevshikova, who first introduced this idea to write such book. Tatiana is former deputy head of legal with Asian International Arbitration Center, and we also have met each other around 5 years ago in Malaysia, when I stayed with this institution for some time. So thanks a lot for joining us. We thought in advance what we would like to discuss, and of course it's not possible today to go into details of arbitration in respective jurisdictions, and basically we wrote a book with some key information on arbitration legislation, arbitral procedure, enforcement of arbitral awards in these jurisdictions, and also in Singapore, in Hong Kong, in Korea. But we decided that it's not possible to go into such details, and probably it's not necessary because we will have this book. But what we would like to do is to discuss a little bit importance of Asia as a region and the importance of arbitration in general, and discuss some specific issues or cultural specifics of arbitration in respective jurisdiction. Because, of course, as I mentioned before, we are practicing international arbitration, which is truly international and global. But at the same time, our cultural background, education, our practice, of course, affect us at least to a certain extent. So it will be really interesting today to discuss what are specific ways how arbitrators, tribunals evaluate evidence in respective jurisdictions, how behavior of counsel is treated, and how arbitrators behave themselves. So our ambitious plan is to discuss this with regard to those respective jurisdictions. But we will start with Alexander Molotnikov, who will share some probably broad picture about arbitration in Asia as a starting point for our future discussion. By the way, last organizational issue, we would welcome questions from the audience, but probably we will have them at the beginning of at the end of our webinar. So we encourage you to write your questions in the chat, but we will address them in the end. Probably if we find some questions particularly relevant for current discussion, probably we will take some questions and address them, but otherwise our plan is to have questions in the end. Okay, so Alexander, the floor is yours.
Thank you, Anna. It's a great honor for me to talk at this webinar when you present your great book, which is devoted to arbitration in Asia. And I'm very glad to see many faces of people who I know and who know me. So I think that at these times when we could see each other only by Zoom or another technical features, it's very, very important for all of us, understanding that we are all community of lawyers who are connected with Asia law, arbitration in Asia, and so on. Okay, dear colleagues, when we are talking about arbitration in Asia, we should understand that all these things are connected with all the things about commercial law and about law system, which we could see in different Asian countries. For example, if you look on China, if you look on India, if you look on another part of the East, we should see that when Europeans began to make commercials with them, when Europeans came to this region, they were very surprised because they could not find government courts. They could not find which were devoted to commercial things. They were not able to find some commercial laws and so on, and they were very surprised. We should understand that traditionally in Asia, the state, the government, did not interfere into the sphere of all the stuff of commercial. The state did not interfere into private life of people. I don't mean private life as you have to serve to our state and so on, but they did not put great attention on business issues because it was considered to be something very low, and on the first place there were warriors or some people who were connected with religious questions and so on. So business was not on the first point for all these managers of ancient times. That's why we are not able to find some commercial codes, or we are not able to find some books which should be divided to the things. All the problems which appeared between rich people, all the problems which appeared between business people, they were solved by the things which were in this community, at the community of people who um, made business, or at the community of people who lived only in this country, or who've come from another country, who made all year-to-year business with all these merchants who live there. That's why I think it's very important for us to understand that arbitration, not state arbitration like we call it in Russia, arbitrage and so on, but the real arbitration is very, very important for Asian countries, because you are able to choose the people who you respect, and you are able to choose people who should make a decision on your case. It is very important. The another thing which we should understand is that very often at different Asian countries, there is special cultural issues when people are afraid to, I could say, to lose their face, because if you go to court, if you go to state court, if you go to this court when everybody could enter the courtroom, and every interested person could listen to your evidences, could listen to another side, we should say that you are not good businessman. It is like public suicide for you, your business suicide. So that's why we should understand that all the things which are connected to arbitration, when people are not allowed to enter arbitration room, because only the sides could participate at these hearings. It is more common for, and it is more understandable for people who operate their business in Asia, for people who do their business at these countries. And we should also understand when we are talking about Asia, we should also understand when we are talking about different commercial issues, that the law system appeared not long ago. The law system, which we could call it a written system, appeared maybe 100 years ago, because before it, as I have already mentioned, there were only unwritten rules. Right now, some of them they're used by people who are occupied with business affairs. Some of them are forgotten, but we should understand that many things which appeared and many things which we see at Asia, they came from Europe. They came from Western countries. And sometimes some law institutes, they're not rather good for all these countries. Sometimes we should understand that some some laws, they are not, people from Asia, they don't like some of them because they didn't grow from the ground, as, for example, you take some system of the courts in England, or you should take some things, some institutes concerned your reality and so on. You should also understand all this issue. And another thing which I would like to say, and to my mind, it's very important to mention, is that to my mind, arbitration have very good perspectives if we are talking about Asian countries. Because you see that very often people from Europe, people from another country, they think that Asia is something like, okay, we have China, we have India, and that's all. It's not true. We should understand that Asia is very, very difficult region. In Asia, cultural issues, I mean, too many things for people who make business. And that's why we should understand that when we try to understand Asia, when we try to understand arbitration in Asia, we should learn all these cultural issues. And I suppose that your book should help not only lawyers, it should help also businessmen, to those people who try to make business with people from Asia, with all those people who try to make business with this new region. And I think that it should help to different countries, to different businessmen, to different lawyers. Thank you very much.
I agree with you that we see really tremendous growth of business with Asian countries, and we see tremendous growth of number of cases in arbitration in different institutions. And probably this is the reason why new institutions are created in this region. And I think that one important thing to remember, and you mentioned this, that Asia is very different. I mean, there are so many jurisdictions, there are so many countries, and each is interesting and unique. And hopefully we will demonstrate this today, and hopefully our speakers will agree or maybe disagree with some of your statements, which are made with a view of a Russian practitioner. But thanks a lot. It will be really interesting. Yeah, thanks a lot. I suggest to continue with, again, we can say this, Russian speakers, and I offer Yana Vaivods to share her views on, first of all, as she is now in-house lawyer, but she also had experience with a law firm, but she also had experience with arbitration institution. It will be really interesting to learn her views on the subject arbitration in Asia in general and arbitration in China in particular.
Hello, nice to hear you, and it's an honor, of course, to be here. I totally agree with Alexander's words because me, as a representative of a huge construction firm, also have the same views, because the idea behind their arbitration is the business interests, and we should respect the interests of our Asian suppliers, our Asian constructors, whatever. Of course, they prefer their arbitration in their region. And we, as a Russian firm, should find the solution which is more convenient for both parties, for us and for our partners from China, Korea, and so on. And in order to find this solution and the best solution, we should understand risks, we should know the legal environment and cultural features. And my point is, despite the increasing harmonization in international arbitration, there remains inevitable differences and arising from our backgrounds, arising from cultural features. And the example is that back office and arbitration centers, arbitrators, sometimes in China. So as an author of a Chinese chapter, the arbitration centers plays more active role. They are like cultural translators for parties. So, for example, they are pushing parties to send emails to each other before the Golden Week. It's the period from 1st October till 7th October, or before the Chinese New Year, because it's the death period, and they understand that it's better to exchange emails before. The other thing is that if parties decided to speak English, of course, we understand that their level can be different. And arbitrators prefer to ensure that everyone is involved on the same page and can understand each other. The other interesting thing that I remind is that it's quite a common opinion among Chinese arbitrators that the goal of the arbitrators to ensure that parties are able to preserve their long-term relationships. So that's why they sometimes can request to use mediation procedure, and it's quite common. The other interesting feature, I suppose, that it's a common knowledge for us that Chinese party or people doesn't like to say no. And during negotiations, it's a very important fact because they use less direct forms of expression like roundabout. And during negotiation, it's better to ask an open-end question and then understand what the other party want to say. And the last thing that I remind when I was preparing to this seminar, it's quite interesting case. When the Hong Kong Court of Appeal had granted leave to enforce a China-seated award, where an arbitrator conducted mediation during a private dinner with one of the party in the absence of another. Of course, the arbitrator paid for it. But Court of Appeal had granted leave to enforce on the basis that such practice was found to be acceptable by the court of the arbitral seat. So I find it very interesting, and we can see how cultural features affect the arbitration procedure. The last thing that I want to add is the common phrase that the good lawyer knows the law and the best lawyer knows the judge. So we should know their cultural features and the legal features of arbitrator and arbitration procedure in China, of course, because it plays a very important role.
Any comments from other speakers at this? I mean, at this just introductory subject that arbitration in Asia is very important, and it's very important for Russian parties and parties from CIS. Okay, it's not disputed. Okay, let's have a discussion with our speakers on the following issues. I know that our audience is interested in enforcement of arbitral awards in respective jurisdictions, but we decided not to mention this, at least in details, because this is described in our chapters, but we wanted to discuss maybe something else which was not described in the book, and this is this cultural specifics in evaluation of evidence, for example. So maybe we can start from some thoughts from our speakers on this subject. I mean, how arbitrators in your jurisdictions evaluate evidence, what they find more credible or less credible, any specifics which is interesting and useful to take into account. So maybe we can start from Philippines, if you don't mind, because I see Jay first. And we will then have a view from India and Singapore, from Thailand and from Malaysia, if you don't mind.
Right. Anna, hi. Good afternoon from the Philippines, from Manila. I guess before I get there, I wanted to also just highlight what has been earlier mentioned, that Asia is not just China. And then Asia is not just Asia when you think about it. In fact, I also wanted to promote the, ASEAN, the Association of Southeast Asian Nations, which is composed of 10 member states. And then when we talk about the importance of arbitration as a mode of dispute resolution in cross-border disputes, I think I also want to highlight the growing number of businesses that are moving towards Asia, and not just China, but also in the ASEAN. In fact, in a recent ASEAN Secretariat survey, it is found that ASEAN is the fifth largest cumulative economy in the world, and so it is not surprising that ASEAN also has some of the most active arbitral institutions in the world. You do have the Singapore International Arbitration Center. You do have the Singapore office of the ICC. You have the Asian International Arbitration Center. We have here with us from Thailand, the THAC. Of course, you also have a lot of other arbitral institutions in the region, which is for me a testament of how, how much growth there has been in this region. And so when our audience thinks about looking at Asia and arbitrating in Asia, it's most likely that they do have business in Asia. And it is comforting to let them know that when they do end up in a dispute, knock on wood, I hope it doesn't happen, that they do have or they do have a wide number of choices where they can go to resolve their disputes. And even before they have their disputes, they can put in their arbitration clauses. The arbitral institutions that are based in Asia, or they can also choose the seats or places of arbitration in Asia. Now, with regard to that, when we talk about ASEAN, the Association of Southeast Asian Nation, it would be comforting to know for our potential viewers here to know that the members of the Association of Southeast Asian Nation do have arbitration laws, and many of them are based on the UNCITRAL model law, which is a basic law, a model law that can be adopted by states. And so, to put it quite oversimplified, the loss of one country in arbitration is similar to the loss of another jurisdiction. And so it is not going to be a new set of laws that Russian lawyers will have to study, or even in-house counsels would have to be familiar with. If you're familiar with the UNCITRAL model law, know that it's very similar in all of these countries. But going now to, I think, transitioning to your question about enforcement of arbitral awards in ASEAN, it would be comforting for our audience to know that at least in the ASEAN region, all of the countries of the ASEAN are signatories to the New York Convention. And again, not to be over legalistic about this, just to know that being oversimplifying it, it only means that there's this one international convention that governs the enforcement of arbitral awards in these regions. Now, there can be, although we're talking about a common convention, meaning it has common text, that can apply to various regions, there can be differences in the enforcement or how courts interpret the New York Convention. And so there can be varying degrees of enforcement in these jurisdictions. And I can say that there is the spectrum is also quite wide. You do have the superstars of arbitration in Asia, where you have Singapore, Hong Kong, where the judiciary, Malaysia, where the judiciary are like, yes, arbitration, we're pro-arbitration, enforce. Strictly construe the limitations for the enforcement of an arbitral award under the New York Convention. But then again, you have other countries that are more conservative, that even if they follow the New York Convention, they construe that quite strictly, I mean, quite, not very much arbitration friendly. And, courts are very protective of their powers. And so these are some of the differences that, Russian companies or just basically anyone who wants to enforce an arbitral award in Asia needs to take into consideration. Which jurisdictions are they going to? They will definitely have to consult local counsel on the specific nuances in enforcing the arbitral award in this country. So, it would be very helpful if you talk to them, discuss your commercial concerns on enforcing. Perhaps there is another way of enforcing it without even going through the court mechanism. But insofar as the Philippines is concerned, the Philippines is, I must say, a pro-enforcement arbitration jurisdiction. I must admit that it has taken quite some time before it gets into this situation, but I am very glad that the recent Supreme Court decisions on the matter have been very pro-arbitration. Like there has been a decision recently, Mabuhay versus Semcorp, and before there's another case, tuna processing case, where the Supreme Court has upheld has upheld the strict interpretation of the grounds for non-enforcement of arbitral awards in the Philippines. With respect to Hong Kong, we do know that it is a very pro-arbitration jurisdiction. So I guess I would say that there is you won't have any issues enforcing your arbitral award in Hong Kong. In fact, there have been some awards that have been not enforced in other jurisdictions, but were enforced in Hong Kong because of the differences between the various judiciaries' interpretation of the New York Convention.
Thanks a lot for this summary. But if we are speaking about arbitral proceedings and some cultural specifics, if any, of evaluation evidence, evaluation credibility of witnesses, if we're talking about Philippines, are there any priorities, or something, for example, some type of evidence is perceived as more credible or not, something interesting for our audience to have some feeling of arbitration in Philippines?
All right. Well, the Philippines is, of course, adopted the UNCITRAL model law. And there are practitioners who does international arbitration. And so the way that they interpret the evidence in an arbitration is not very different from how other arbitrators in neighboring jurisdictions would do it. However, there is a tendency, and this is something that a lot of people do not know. The Philippines is actually a civil law jurisdiction, meaning we do have a civil code. But in practice, in court practice, we are very much influenced by the United States. And so we have a common law practice in courts. And that is also very evident in arbitration. Practitioners themselves tend to be more tend to look more into the common law way of appreciating evidence. And so we do have the testimonial evidence, which is very important. Cross-examination of witnesses is very important. Documentary evidence is very important. Legal precedent is very important. There's not much weight on the let's say, commentaries of legal experts or their books, as opposed to a different way that perhaps a civil law jurisdiction could look at it. But yes, that's for the Philippines. It can be quite confusing because it's civil law, but the practice is quite common law.
That's interesting. Thanks a lot, Jay. Thanks a lot. Abhinav, what can you say about India and Singapore? You have a not easy task, or maybe easy task for you to share views on two jurisdictions.
Thank you, Anna. Before I say anything about India and Singapore, I'm going to do exactly the same, what everybody said, is to state the obvious in my words, which is about Asia and arbitration. So just, how we look at the bloodline of families, bloodline of people. I mean, I'm always interested on where arbitration was born and how it has become what it has become in Asia today. So for the audience today, I think, as Alex also mentioned, that arbitration essentially started in Europe. And I'm very happy to be a part of the organization which actually significantly contributed to the origin and the spread of arbitration. After the First World War, a group of merchants came together, and to facilitate trade, the ICC was born in 1919. We are more than 100 years old now. And arbitration within the ICC was born in 1923, which is almost 100 years now, where the ICC, International Court of Arbitration, was born. But look at what has happened in the last 100 years, right? We now have an economy, which Kansri Cecil Abraham also said, that has moved from the north to the south and from the west to the east. And the biggest beneficiaries of this economy, this shift of economy, are China, India, Asia, ASEAN, as Jay also alluded upon. Just to give it in perspective, the Asia Pacific, and allow me to add Pacific into it, although it's a very important part of this region. The Asia Pacific accounts for 40% of the global GDP as on date. And in the next 20 years, Asia Pacific will account for 50% of the world's global domestic product. Therefore, it is unsurprising, and again, what Jay was speaking on, about that you have seen the rise of arbitration in Asia. You have a SIAC, you have an HKIAC in Hong Kong, you have an AIAC in Malaysia, and of course, ICC has opened up its offices in Singapore, its 11th office, case administration team, and the 12th one opening in Abu Dhabi. We forget actually the whole of Middle East is actually Asia, which is huge in itself. There are close to 50 odd countries in Asia. However, this spread of arbitration, Anna, and I'm sure you would agree with me, is not even. There are developing jurisdictions and there are developed jurisdictions. So to give an example, even whilst this arbitration, which started in Europe, seeped in the Americas, and has now only come to Asia, more so in the last 10 years, but sort of started coming in the late 90s, it is now taking shapes and different sizes and forms in different countries. So on one hand, you have Singapore, Hong Kong, whilst on the other hand, you have Indonesia, and on the other hand, you have in India, and you can see that the growth, the understanding, the culture of arbitration in all different jurisdictions in Asia are actually different. So it is not a homogeneous spread of arbitration in Asia. It is at different levels, but suffice to say that because of the economic shift, Asian jurisdictions need arbitration. And I think that's what Alex was also alluded to. Now, because of this developing and developed difference, how the arbitrators behave, the cultural differences between councils, the conduct of councils, the conduct of arbitrators, that again is different in different jurisdictions because of two reasons. One, because inherently, culturally, they are different people. And two, because their understanding of international arbitration is not uniform. Different jurisdictions have understood arbitrations to be different. To give you an example, now, because of this difference, different parties have a different understanding of what liberties they can take with each other, what restraints they can have with each other. Specifically about India and Singapore, which Singapore, of course, is undoubtedly, unquestionably one of the most advanced arbitration jurisdictions, not just in Asia today, but in the world. The Queen Mary survey now ranks Singapore as the third most preferred seat of arbitration in the world, and certainly number one in Asia. In fact, now from where I sit at the ICC, I see a lot of Russian disputes come to Singapore. They are now seated in Singapore. Originally, historically, they were in Europe, in London, or even more so, I believe, in the Nordic region. However, both India and Singapore are common law jurisdictions. So the way arbitrators appreciate evidence is quite similar. The way arbitrators interpret the law is very similar. But again, when you look at India, the relationship between the bar and the bench is very, I would say, different compared to a relationship between the bar and the bench and arbitration practitioners in Singapore. And the reason behind that is that in Singapore, you have foreign law firms, you have local law firms who have a dedicated international arbitration practice. You can segregate those who go to the court versus those who do just purely international arbitration. India is growing. It is still not yet at a stage, also because the Bar Council of India rules currently do not allow foreign law firms to establish offices there. Indian law firms are the dominant force in India, and the line is a bit mixed. Everybody does arbitration and everybody does litigation. Everybody appears before judges, and when they retire, same people appear before those judges who have been appearing for the last 40 years in arbitrations before the same people. So you can imagine a lawyer who's been appearing before a judge for the last 20, 30, 40 years, now appearing before the same judge as an arbitrator. And you can understand the dynamics between that relationship versus a lawyer who is appearing for the first time before a judge in a different jurisdiction like Singapore. The other, I think, very important cultural difference that I see, although both are common law jurisdictions, Indian awards tend to be quite long. We still follow the common law system. The judges who then become arbitrators have all their lives followed the common law system of basing their judgments on precedents. So you will see a lot of precedent and a reasoning coming out of those precedents. And therefore, the judgments tend to be longer, as opposed to civil law jurisdictions where judgments tend to be shorter because they don't tend to follow the civil law or the common law practice. Now, Manila maybe, Philippines may be a bit of an exception. So the Indian awards, therefore, the arbitrators tend to follow the same methodology which they used to apply as judges. The pleadings tend to be longer. Singapore, I would say, is a bit more restrained. I think it's more, they do follow the common law system. And I think it would be unfair to generalize this. But if one were dared to generalize this, then I would say that the Indian system still remains very verbose, very, that's the right word, there's a lot of prolixity as compared to Singapore. Then, in terms of appreciating evidence, like I said, insofar as the probative value of evidence is concerned, what is the test that Indians and the Singaporeans apply? I think it's broadly the same, which is each party must prove the claim it's claiming. Now, while proving their claim, is it the preponderance of evidence standard, or is it beyond reasonable doubt? Again, when it comes to matters like fraud and corruption and other serious issues, allegations, arbitrators tend to go for more beyond reasonable doubt standard. When it's more commercial, when it's more civil, I think the standard still is about the preponderance of evidence in both jurisdictions. Then the expectation from the arbitrators. Now you see in India, when you nominate an arbitrator, the parties still, to a large extent, although it is improving at a very fast pace, expect that arbitrator to be the parties' arbitrator, to sort of be the party's lawyer or an advocate on the tribunal. That understanding is, of course, changing as people are getting to know more and more about arbitrations. And therefore, the arbitrators also sort of get, it's like ink in water. Once that thought goes into your head that I am this party's arbitrator, you have a subconscious bias towards the party or a conscious bias sometimes towards the party. And that's the education about arbitration, which is, again, the difference between a developed and a developing jurisdiction. In Singapore, I think arbitrators and the parties have a better understanding that even though an arbitrator has been nominated, the arbitrator is expected to act completely independent, completely neutral vis-a-vis the party that has nominated the arbitrator. So these are some subtle cultural differences. Now, who's a good arbitrator and who's a bad arbitrator? I think it's fair to say that that understanding is quite common in India and Singapore. A good arbitrator is someone who's on top of the matter, is reasonable in cost if it is ad hoc arbitration, quick, fair, follows due process, and writes a well-reasoned award. That's a very good arbitrator. But going back to Yana's point, who said that good lawyers know the law and the best lawyers know the judges. I think the parties sometimes expect that a good arbitrator is also the arbitrator who plays on the parties' side. And a bad arbitrator for everyone is slow, unreasonably expensive, have not read the papers, and writes a bad award. Which I'm happy to say is quite a consistent understanding of who a good arbitrator and a bad arbitrator is around the world. So I don't see much of a cultural difference there, except one minor difference, the expectation of the parties from that particular individual. Man, woman, doesn't matter. These are some of the things that have come to my mind, and I'm happy to expand on it further after I've heard the other speakers. Thank you.
It's amazing, very interesting. Just a short question, maybe not the most evident one, but I thought when I listened to you, you mentioned that Indian lawyers tend to write long papers. It's still a cultural tradition. So I wonder, I know it's a very strange question, but I wonder if other councils write shorter pleadings, will arbitrators treat this as less persuasive or strange, or how this will be? I mean, now we have a lot of discussions that we need to write shorter and more precise pleadings, but I wonder how arbitrators will perceive this. Maybe it's still cultural traditions for arbitrators to expand, I don't know, 400 pages of pleadings.
Yes, that's a very good question, Anna. It's a chicken and egg story. You don't know. There are some arbitrators also, and let's be very fair, who like short, crisp, to-the-point arguments. And then there are those who are very used to this long pleading style. There are lawyers, and I can say that the quality of Indian lawyers is excellent. Some, I think, just write long pleadings, if I be completely honest, is because what you said, if they were to write smaller pleadings, whilst the other opposing counsel has written lengthier pleadings, then the client is going to come up to the lawyer and say, hey, look, my pleading is just 5 pages and you've got 500 on the other side. You're not a good lawyer. I mean, it's a cultural issue, right? And it's changing. I see lawyers now giving crisper documents. I see arbitrators in India now asking for crisper documents. But this is a systemic change. It's a cultural change. It is that bloodline needs to change. It is changing, but it is going to take some time. Also, India is a diverse country, Anna. Food, language, religion changes every 100 kilometers. Even I don't know. There are parts of India, many parts of India, where I don't understand what's happening in the country. So to make all of this like one common ball of like good arbitration is going to take some time, but I'm happy and proud to say that we are absolutely on the right track in light of the current government and the initiatives it has taken and all the policy frameworks that are coming about in the country.
Thank you. Thanks a lot. Thanks a lot, Abhinav. Tatiana, so what is your experience? How can you share? I mean, what can you say about any cultural specifics of evaluation of evidence? And actually, Abhinav has also mentioned behavior of counsels, behavior of other arbitrators. If you would like, you can share these issues at the same time as well.
Sure. Thank you very much, Anna. And I would like to thank the organizers of this event and all the speakers and Tansri for joining this session today. It's a great pleasure to finally see the results of our work. And since everyone started this discussion and their presentations of an overview about Asia, I'd like to mention that, and I'd like to recommend actually a book which is titled The Future is Asian by Parag Khanna. And this book is exactly on point for today's discussion because the author discusses what Asia is, which countries historically belong to the Asian continent, and how the political and economical blocks were formed. And once you read this book, a lot of cultural differences will be also very easily digested by the audience and by everyone who is interested. Speaking of Malaysia, I spent almost 5 years in Malaysia with the Asian International Arbitration Center. So I'll try, and it's hard to summarize everything in course of this discussion. However, I'll just try to point out the main cultural differences and the main specifics about Malaysia. Malaysia is a common law jurisdiction, and if you're interested to read the case law coming from Malaysia, you will definitely notice that a lot of judges, they refer to the English law, Indian case law, Australian case law, and Singaporean case law. Therefore, there is no much difference when it comes to the tests which are being applied by arbitral tribunals as well. Speaking about enforcement, surprisingly for many people, Malaysia is a very pro-enforcement. It becomes more and more arbitration-friendly jurisdiction. And specifically, if you're interested, you can check the 2018 Herbert Smith overview of the ASEAN jurisdictions. And apparently, Malaysia was ranked as the second most trusted jurisdiction within ASEAN after Singapore. More than 60% of respondents of that survey, they actually recognize that Malaysian courts, they are very pro enforcement nowadays. There's a lot of judgments starting from 2014, 2015, which you can identify, and I'm happy to share references with our audience later on. But mainly what you need to know for the purposes of today's discussion is that one of the major concerns when it comes to the enforcement of foreign arbitral awards is public policy, how this public policy argument is being interpreted in foreign jurisdictions. And when it comes to Malaysia, Malaysian courts explicitly explained and elaborated that public policy is being interpreted narrowly, which makes it very comfortable for foreign parties to apply for the recognition and enforcement of foreign arbitral awards in Malaysia. Speaking of, if we try to compare enforcement in Singapore, Hong Kong, and Malaysia, all three countries, they are very pro-enforcement. In terms of costs, Malaysia is a bit more competitive because it's really, really affordable to enforce arbitral awards in Malaysia. If I'm not mistaken, it costs around $900 to simply file court papers for the recognition of foreign arbitral awards. And it's also very competitive when even if the case goes up to the federal court, it's still very competitive in terms of costs. Speaking of the evaluation of evidence and how arbitral tribunals assess evidence in Malaysia, it depends on whether the matter is domestic or international. There is an Evidence Act 1950 in Malaysia, but obviously it doesn't apply in arbitration. However, it is possible for the parties to opt in for certain provisions of this act. And if they don't, tribunals quite often still rely on certain provisions as a guidance for them. If the parties have not agreed on the applicable provisions from that act, then the tribunal will rely on the natural justice and the principles of natural justice. As Abhinav mentioned, the same tests are being applied, the preponderance of evidence or tribunal checks on the ground takes into account whether the evidence submitted is beyond reasonable doubts or not. Speaking of the credibility of evidence, I had this discussion with one of the Malaysian arbitrators just a few days ago. And the approach overall is just to look at the dots, because most of the things are connected and intertwined. So if the connections in the story actually have the dots joined and make sense, it's likely fact in the absence of strong indicators to the contrary. And of course, all tribunals also do the tests or reality check from several angles. Just something else on the cultural differences very briefly, because I had some experience in dispute resolution in Russia and in Asia. So if you ask me about some cultural differences I noticed in arbitration, it's more common for the Asian parties to involve arbitral institutions in the appointment processes. So in my view, Asian parties and Malaysian parties, they ask arbitral institutions to appoint arbitrators much more often compared to the parties coming from the West overall. And even if you look at certain provisions of the institutional arbitration rules, and if we take the AIIC arbitration rules 2018 as an example, there is even an additional layer, which is also makes Asian parties more comfortable when it comes to the appointment processes. And I'm speaking about the confirmation of arbitrators by the director of an arbitral institution. The way it works is that even if the parties nominated their arbitrators, let's say the second and the first and the second arbitrator, they still would like a conflict check, for instance, to be done by the arbitral institution and the director to confirm those selected arbitrators. The second difference I noticed is the frequency of the use of tribunal secretaries. It's much more often to use tribunal secretaries in the Western world compared to Malaysia, for instance, but it's still something that is being developed at the moment, and I expect more and more institutional counsel as well as younger arbitration practitioners to be appointed as tribunal secretaries in the next few years. Needless to say that Malaysia is also a Muslim country, and some differences are coming from the religious differences as well. For instance, a lot of hearings they have, they do schedule breaks for prayers, especially on Friday. Sometimes the parties may have 2 hours breaks, if not more. So it's also one of the cultural differences. And I guess one of the most frequently discussed issues nowadays is the issue of virtual hearings. In my experience, Asian parties, they also have a bit less experience with virtual hearings. They had a bit less experience with virtual hearings before the pandemic. But once the lockdown was announced in Malaysia, and it happened in mid-March 2020, more and more parties, their counsel, and even very conservative arbitrators, they started considering virtual hearings, or at least having a hybrid hearing where, for instance, the parties postpone the in-person hearing until the end of the lockdown, and trying to be in the interest of the time efficiency, they did some examination of witnesses on the virtual platform, for instance. I think that's about it. If we speak about a brief overview of jurisdictions, if you have any other questions, Anna, please feel free to ask.
Thank you, Tatiana. But what about arbitrators? Is it a more common approach to give the parties initiative, or are arbitrators more proactive in examining witnesses, examining evidence, giving instructions to the parties?
Everything is on a case-by-case basis. So it depends on the case, it depends on the tribunal. Some tribunals are more active, some tribunals are less active. There is no such thing as one size fits all.
Okay, thanks a lot. So we can go now to Thailand.
So let me introduce myself again. So my name is Suparak. I am a counsel of the Thailand Arbitration Center, so the TSAC. So about in my view, in this age of disruptive technology where artificial intelligence is displacing many conventional human behaviors, so including the manner in which international trade and other business transactions are conducted, the method of resolving commercial dispute must adapt this change as well. So the traditional way of litigating commercial dispute in court may still remain the primary way to resolving them. But sooner or later, the court will become like they will call it forum non-convenient. So to try this dispute. And distinct advantage of the arbitration over litigation is that the party can appoint natural to settle their dispute. What is more, they have the flexibility of choosing the rules of governing their arbitration proceeding instead of submitting themselves to the rigid rule of the court procedure. So the current law on the arbitration is the Thailand Arbitration Act 2002, which mostly follow the UNCITRAL model law on international commercial arbitration. So in the view of the enforcement of foreign arbitral award, the extent of the Thailand commitment under international agreement. So everyone know the New York Convention, which is Thailand accede on 24 December 1959, which is now 62 years already. So for me, I think on the enforcement on the foreign award, so mostly the Thai court will not intervene any on the arbitral award. Mostly they will fairly from when the arbitrator render the award. And on the view of the evidence, in our traditional, mostly the arbitral tribunal may determine whether to hear live witness testimony or have the witnesses submit written statement. The arbitral tribunal must give the party sufficient advance notice of any hearing of evidence and of any meeting of tribunal for purpose of inspection of that material, places or documents, or statement of claim or statement of defense, statement of request, document or any other information supplied to the arbitral tribunal by one party must also be communicated to other party. Any report of expert witness, if any, or documentary evidence on which the arbitral tribunal may rely in making its decision shall also be communicated to the party. And about the time to this, there are not set time limit for giving of advance notice or communication to the other party, because in the practical we will let the party to decide the time set, but it have to make sure that it will be not used in the delay tactic mostly. But the most important on our arbitral process is the party shall be given a full opportunity of present their case in accordance with circumstance of the dispute. Therefore, reasonable periods of advance notice should be given as well. So we will emphasize on the notice. So both parties have to aware of their notice and when they submit the documentary evidence. So in practical, usually the party will usually attach the document on which they rely to their statement of claim and statement of defense, and also witness statement. In arbitration under our rules, the procedure they may be separate tribunal direction to exchange list and copy of all document on which the party rely. There is unlikely to be any further requirement for production of other document in the party process or control. And the party can apply to the tribunal or court for an order requiring disclosure or document held by the other party as well. However, the requested document must be clearly and narrowly identified either individually or as a clearly defined category. And the need for disclosure must be properly justified in the view of the taking evidence in our arbitration process. Yes, on this evidence aspect, so I think I will share from just this.
Thank you. Thank you a lot. Right? And what about arbitrators? Have I understood correctly that arbitrators usually will not take a proactive approach, so they probably rely on documents, evidence submitted by the parties?
Yes, okay. I think everyone knows that the underlying of the arbitration process is on the party autonomy. So mostly it's depend on the party to choose their procedure, to choose their rule, and also the equality to present their case. So our arbitrator will not serving as a judge. So they will serve as the referee. So they will give the full opportunity on the both sides to let's say in case the claimant would like to produce further evidence, so the arbitrator will not decide it immediately at that time. They will ask another side first and see the rule, what the rule says. So in case the respondent object the request from the claimant, so the arbitrator will decide if that document is sufficient relevant to the case or is a materiality to the outcome of the case. So they will allow to produce it.
Thank you. Thanks a lot. Thank you. Jay, would you like to comment also on behavior of counsels and arbitrators, because we first discussed issue of evaluating of evidence, but we have not discussed are there any cultural specifics in what constitutes good or bad behavior of counsels, good and bad arbitrator?
All right. Well, for the Philippines, I think it would really depend on who the counsel is. There are counsels who are very experienced on this matter. It's easy to see online what are the best law firms that do arbitration. And if you are represented by these counsels, then you can be quite assured that at least what you will expect from them would be similar to other international law firms. You know, how they present their evidence, how they carry themselves. It's going to be quite similar. However, one thing that I noticed is because in the Philippines, because arbitration is also becoming very popular, the practice of arbitration is no longer limited to the big firms. There are also smaller firms who have clients that get into arbitration. And when those happen, oftentimes it is their first time to do arbitration. And they carry their court practice in arbitration. I've had experience where some counsels would request the rules on evidence from the rules of court to be used in the arbitration, or requiring certain practices in court, like mandatory practices in court, to apply in arbitration. But I think it's only normal for a developing jurisdiction like the Philippines to encounter that. The more international arbitration cases that the Philippine lawyers would take, then the more knowledgeable they are. The knowledge transfer from international arbitration and international practitioners to local practitioners would be faster, and that is of course to the benefit of both the counsel and also for the benefit of the client. In terms of arbitrators, okay, there's another note that because the Philippines adopted the ancestral model law, you do not need to have local counsel to represent you in an arbitration. You can of course have a foreign counsel represent you in an arbitration in the Philippines. If it's seated in the Philippines, so if ever you just want to hold your hearings in the Philippines, you can bring your foreign counsels. But insofar as local talent is concerned, we do not have a lack of talent that can represent parties in international arbitration. For arbitrators, it is also quite similar. Many of the Filipino arbitrators, if you appoint a Filipino arbitrator, are very familiar with domestic arbitration in the Philippines, which is quite different in practice. And many of them are also very, very familiar with construction arbitration, which under Philippine law is not covered by the model law. So CIAC, or CIAC, not the SIAC. The CIAC is an institution in the Philippines that has, under law, exclusive and original jurisdiction over construction arbitration. It's a quasi-judicial body. It is not like any other commercial arbitration body. And the procedure in construction arbitration is very different. And so sometimes if they're very used to construction arbitration, which is very local, they sometimes apply the same practices in international arbitration. So it is really important to choose the background, to choose your arbitrator based on their background. It depends if you are starting construction arbitration in the Philippines, regardless if you're a foreign party, if you are going through CIAC and you know an arbitrator who is used to that kind of procedure, then expect something very local. Some of these would be, because it's quasi-judicial, the due process part can be lacking. Like they would say, do this, do that, without even consulting the parties, which is quite unheard of if you think about commercial arbitration. It's always about consulting the parties what they want, and if they agree, go with it. And if there's no consensus between the parties, then the tribunal can order the procedural matter. So that can be quite a shock sometimes if it's the first time you're appointing a Filipino arbitrator. But as I said, just like foreign counsels, it's only a matter of time when these Filipino arbitrators get more experience from international arbitration and learn also from their neighbors, the practicing practitioners from let's say from Singapore, from Hong Kong, Malaysia. And I think it's going to the right direction. As Abhinav said, the development of arbitration in Asia depends on these jurisdictions. Some are ahead than the others, and I think the Philippines is on its way. I'm not saying it's starting, but it's going there. It's getting there. It's not the worst, but I would say it's also not the most, not the best when you compare it to Singapore and Malaysia and Hong Kong. But it's getting there.
But I saw from your profile that you are a youngest member of a special committee on amendments to arbitration law, if I mentioned this correctly. So probably future of legislation is in your hands as well.
Well, I can tell you a lot of war stories about that. It's about talking with people from a different generation and how they perceive arbitration, and actually the drafters of the original arbitration law, when you try to tell them you have to amend it just to comply with international practice. I must say that it takes a while to convince them, but they are quite open-minded, and that's why I'm saying that the Philippines is going to the right direction.
Sounds great, and we wish you all the best in these efforts. Thanks a lot. Maybe this is time to have some questions from the audience, if there are any. I wonder, until we have some questions from the audience, I wonder, I note that Abhinav mentioned that, for example, in India, there is a tendency, at least this is how I understood this, to appoint retired judges as arbitrators. So the same people appear before the same people in litigation and in arbitration. At least this is how I understood this. How is it in other jurisdictions? I mean, in Malaysia, in Thailand, in Philippines, are there any preferences? I mean, whom parties usually nominate as their arbitrators? It's just, I'm just curious.
I think, Anna, you understood perfectly well. I think this phenomena of appointing retired judges, I think it is not only prevalent in India, it is equally prevalent in the United Kingdom, in the United States, in Canada, in Europe, in Singapore, in Malaysia. And I think there is sense in doing that. However, the small difference is that in Singapore, for instance, the acceptability of a younger arbitrator or the opportunity for a younger arbitrator, whether it's a man or a woman, is still slightly more in the eyes of the parties compared to India. Again, also the number of people in India are much more than the number of people in Singapore. But again, that is changing. So to give you an example now, under the ICC's new expedited procedures, they're not really new now, they've been at it for some time. The only new thing that has happened is that we've changed the rules, and now we have a 2021 ICC rules, wherein the limit of the expedited procedure has increased from $2 million to $3 million. Now, in these kind of cases, whether it's India or whether it's any other part of the world, the ICC court, to the extent, tries and appoints a younger arbitrator, not a retired judge. And we are now...
Excuse me, just a quick question. So-called young arbitrator is different in different regions. How young is young arbitrator in India?
That's a very good question. In my view, anybody who's not a retired judge is a young arbitrator. Okay.
Okay.
so that age, you know, we've had an ICC, we've had somebody as young as 28 years. But if my sense of being at the ICC for 10 years, I think anything up to 50 is young, is a young arbitrator. You know, we regularly have arbitrators getting their first appointment at the age of 45, 46, 47. And I also actually have numbers that the average age of men for ICC arbitrations is more than the average age of women. And of course, there's a reason behind that, because men started early with their arbitration practices as opposed to women. So there are more men who do arbitration compared to more women. And therefore, the women who get appointed tend to be younger compared to the men who get appointed. But I think the better statistics, Anna, is that when it comes to the average age of men and women that the ICC appoints, that is much lower compared to the average age of men and women that are appointed by the parties. And that goes to show that I think there is a great emphasis on diversity. There is a great emphasis to appoint younger arbitrators, to make a shift away from the retired judges. And I think retired judges don't even want these small $2, $3, $4 million cases. So it just serves everybody's interest to train the next generation of young arbitrators, which I think the ICC remains stellarly committed to.
Thank you. Thank you, Abhinav. Any comments from other speakers on preference on arbitrators?
Sure, I can just briefly add something else. I echo what Abhinav mentioned about the appointment of former judges in arbitration. It also happens in Malaysia, but of course everything depends on the expertise in a certain field of arbitration and a certain field of law. There are some specialized courts in Malaysia, for instance, construction courts or admiralty courts. So apparently judges who already have great experience by the moment they retire, be it construction law or maritime law, they are quite often being considered by the parties and nominated by the parties. So yes, I do agree that former judges, they are being considered as arbitrators in common law jurisdictions quite often. We were also planning to share some interesting examples, if we have some examples to share, speaking of arbitrators and how arbitrators can be different in Asia. And I just have two very quick examples to share with you today. A lot of arbitrators, they're actually very kind-hearted. And it's quite interesting what kind of arguments are being considered, or what kind of justification are being considered for by arbitrators when it comes to, for instance, a request to postpone a hearing or a request to extend the deadline. Some time ago, we had a case where a leading counsel requested to postpone a hearing because his co-counsel's wife delivered the very first baby. So they didn't know what to do. And they literally explained, they spent one paragraph in their submission explaining how is it different to have a first baby and the second baby and or any other consecutive baby. And the tribunal actually accepted it and agreed on the hearings for the few days. It was a domestic matter. And the other example is that we had a hearing where on the one side we had a major law firm representing one of the sides, and the other side was represented by very young lawyers who didn't have any experience in arbitration at all before that particular hearing and before that particular matter. So the tribunal was actually very receptive and understanding and wasn't pushing, it wasn't aggressive. And interestingly enough, at some point, I think it was at the preliminary meeting, if I'm not mistaken, the counsel for the opposing side, the very experienced counsel, he started helping out the less experienced lawyers, explaining what will happen next, how they can negotiate, and what else can be done to help each other in order to understand each other better. And such attitude actually helped the parties, and they managed to sign the settlement agreement 2 or 3 weeks after that preliminary hearing. So it was something very unique, I would say.
Wonderful, wonderful stories.
Just add to Tatiana's example, and I call this the wedding story. And everybody knows, the Indian weddings are interesting. They go on for a very long time. There are lots of events, lots of functions. It's like the big fat Indian wedding. So there was this ICC arbitration, I remember, where the hearing got continuously postponed many times. The parties were very litigious. The claimant wanted the hearing. Respondent was trying to be a little difficult, and the respondent changed his counsel. And finally, it was decided almost 7-8 months in advance that the hearing will happen on a certain date. This was after the hearing had been postponed several times. Finally, the hearing was coming on board, and then claimant wrote an email to the tribunal, much to everybody's surprise, including that of the tribunal, that we've just had an ex-parte communication with the respondent. It is the respondent's daughter's wedding, and the claimant would be happy to postpone the wedding. Now, look, this was a foreign tribunal. They were flabbergasted. They couldn't understand what is really going on out here. Why is a claimant's counsel calling up the tribunal and telling the tribunal, I am okay? And this is the same claimant who has been pestering the tribunal to have the hearing. So the tribunal was like, are you sure you want to do this? And the claimant explained that, look, family comes first. This is his daughter, and it is a daughter's wedding, and we will not raise any objection. That's very cultural. That's very specifically cultural. Everybody understood on the other side that this is unavoidable. The wedding was not preponed before. There is no question of postponing the wedding. And it was just so, it would be difficult to see that in any other culture. Maybe Russia, I mean, also, India and Russia are historically been very close friends, and family again plays a very important part in both countries. I don't know. Would that happen in Russia, Anna, though?
First of all, I like this story a lot. I don't know, weddings in Russia are not so long as in India. They usually take part on weekend, so probably I don't want to say anything bad about Russians, but I think that probably this will not be a good excuse, because another council may say that nothing prevents you from participating during a week. But who knows? But I like your story, Abhinav. Thanks a lot. Yeah, this is very interesting touch. Yeah.
I think one more thing that parties need to consider when they're in Asia is the long Chinese New Year holiday. there are, I've seen procedural orders that were, have to be. I mean, they actually they make sure that they carve out nothing is done during this very long Chinese New Year holiday. I think it's similar to other countries. For example, in the Philippines, I just had an arbitration meeting with the tribunal, and initially we mentioned that we want the arbitral award released in December this year. And then the tribunal said, "Are you sure you want to do it in December?" It kind of asking us, can we just do it in January? Because it's Christmas, so we don't want to work in December. So, they need to be conscious about the holidays happening in wherever your arbitrator is located.
That's a very good point. It's Hari Raya in Indonesia. It's Diwali in India. It is Chinese New Year in China, Singapore, Hong Kong. It is every country has these big pockets of holidays, which the tribunals often take into account. Europe is more standard. I mean, it's Christmas, it's your Thanksgiving, or but in Asia you have to be very specific not to have hearings on the day where the country is going on a holiday.
Thank you, thanks a lot. I see questions from the audience which are related to enforcement. I think we mentioned this in the beginning. The question is, what is overall approach to enforcement of arbitral awards in your jurisdictions? I think that this was covered by our speakers, that basically there are, of course, more pro-arbitration jurisdictions, but overall all jurisdictions try to amend the laws, legislation, and attitude of judges changes, and now it's easier and easier to enforce arbitral awards.
Anna, if you can just quickly add up something here.
Yeah, sure.
If I take in ASEAN is currently working on the special protocol for the ASEAN countries to kind of make the enforcement procedures uniform, and it's quite an interesting initiative. So there is an effort to level the playing field basically within ASEAN. I'm not sure whether at what stage of work this project is, but it is quite interesting as well, quite remarkable for the ASEAN countries trying to, improve and make ASEAN countries, ASEAN jurisdictions even more arbitration friendly.
As someone coming from ASEAN, I'm very hopeful as well that something will come out of this. But in ASEAN, they work by consensus. So I hope they agree on something to really make this work.
Yes, it's always, when a lot of participants involved, it's always very difficult, to reach some consensus. Okay, I think that we have no further questions from the audience. So if you would like to maybe to summarize, or maybe to wish to our audience something in 1 minute, last final remark, the floor is yours.
I think my only concluding thoughts are that I think it's a very exciting time that we are living in. I think it's a very exciting time that Russia is living in particular. I think it's a very exciting time for the Russian arbitration system, the licenses being given, the arbitral institutions being allowed to administer arbitrations, and of course there is an administrative angle to it. I think it's an exciting time for Russian companies to look for alternative venues, for different venues and seats of arbitration to expand and grow their businesses. I think it's an exciting time for all the things that Russian industries are excellent at, and we see that in Asia. We see offices being set up in India. We see trade being increased between Russian parties, with Indian parties, with all around ASEAN region. And I see that this is, for all of us on this panel today, I think for the next 20, 30, 40 years are going to be very exciting in the world of arbitration. And I would just like to end on that very positive note.
Thank you. Excellent, excellent point.
I can be the next one. I have two key takeaways for today, for the discussion today. The first one is that, yes, there is a lot of cultural differences between the Russian-speaking world and the Asian countries, but at the same time, there are so many commonalities. And if you're negotiating a contract, if you're negotiating arbitration clauses, or if you're already, faced with a dispute with an Asian counterparty, just try to find commonalities. Try to understand and focus on commonalities instead of differences. That's the first one. And the second one will be just try to keep your finger on the pulse. Asia is such a happening place. So many interesting things are happening there in terms of legislative developments, in terms of innovations. The Asian jurisdictions and the Asian arbitral institutions contribute to the world of arbitration. So there is a lot of opportunities and for everyone, whether you're an in-house lawyer or a legal practitioner, just try to be on top of what's going on.
Thank you. I like this. Yeah, I agree.
I can go next. Well, first of all, thank you for inviting us. This has been a very fruitful discussion from various jurisdictions. And I think what I can say is I echo what Abhinav and Tatiana has mentioned, that that Asia is booming these days. The next years, there will be a lot of exciting developments. It's an opportunity, it's a fertile ground for opportunities for countries, for businesses trying to go out of their their countries, their own countries, reach out and just grow, become a truly international, multinational company. It is the time is now, I think. But if you are going out, what I can really just say is, if you're looking for a place where you want to do arbitration, if you're in the negotiating table, talking about which institutions, which seat, which place, which venues to go to, just the simple matters that you need to think of is whether this country adopted the model law on international arbitration. If it has, that checks the box. Another is, does this country adopt the New York Convention on Enforcement of Foreign Arbitral Awards? That's another check in the box. Get advice on the arbitration law of the seat, get local advice on the arbitration law of the seat, and also get local advice on the law of the potential place of enforcement. You want to be sure that even before you start your dispute, you at least have this insurance in your arbitration clause, that at the very least, at the time of the signing of the arbitration agreement, that you will have an effective dispute resolution clause that would only make dispute resolution more efficient rather than more complicated. That's all from me.
Thank you. Yeah, sounds great and reasonable from business perspective. Yeah, I agree.
I suppose I will be next. Thank you for this very interesting discussion. And I suppose that all questions about enforcement arising from weakness of the judicial system, and but now the situation changing, and China and other countries and Asia is also booming. I absolutely agree with the colleagues. So, and in my opinion, the future is the synergy of Asia, Russia, Europe, America. So, and I think that this seminar and the opportunities of this seminar and what we see now just highlight this thing, and it's quite exciting, I suppose. So thank you. It was very interesting.
Thank you, Jana.
Yes, first, I hope everyone stays safe at the very hard time of the health crisis. Okay, so okay, I think for a long time the arbitration has been promoted as an alternative means of dispute resolution. Its increasing popularity is mainly attributable to its flexibility nature, which enables it to keep pace with the rapidly changing in business landscape. Most of Asian countries, especially in Thailand, is a long-standing member of the New York Convention, so thereby allowing foreign arbitral award to recognize and enforce within its territory. So, conversely, the award can be enforced in, I don't know, it's 170 member states across the world who exceed the New York Convention. Yes, so further effort have also been, I think it depends on the further effort have also been made to relax certain law and the regulation to facilitate the participation of the foreign arbitrator and the council. I think, okay, thank you. Sorry.
Thank you.
Okay,
thank you a lot. We really appreciate that you joined us, and thanks for comments. Okay, thanks a lot to our speakers. It was really a pleasure having you all, and thanks. I know that it's afternoon in your respective jurisdictions, so thanks a lot for joining us, and let's stay in touch.
Thank you so much. Thank you.
All right, have a nice day.
Everyone.
Thank you.
Have a nice day.
Have a nice day. Bye.
Bye bye.